Execute this yield, Prescott Chambers sneered across the mahogany conference table, his fingers drumming against the legal documents spread before us. The morning light cut through the floor-to-ceiling windows of the Vertex Industries headquarters, casting sharp shadows across his face. Sign the resignation form, Finian. You're done here. My hands remained steady despite the adrenaline coursing through my veins. 4 years of 16-hour days, missed birthdays, relationships sacrificed on the altar of innovation, all culminating in this moment. The document before me would erase my 4.1% proprietary royalties from the very platform I had architected from the ground up. But Prescott didn't know about the contingency I had embedded into the original intellectual property agreements. Nobody did. The rights are mine, he continued, leaning back in his leather chair with the confidence of someone who had never been told no. You were just an employee, a very well-compensated employee, I might add, but an employee nonetheless. I picked up the pen. If you're finding value in stories about corporate power plays, workplace integrity, and the consequences of greed, you might want to stick around. This is the Corporate Vault channel, where real experiences from the business world reveal truths that most executive suites would prefer stayed buried. We're working toward building a community of 1,000 people who understand that knowledge is the best protection in any professional environment. The subscribe button is available if this resonates with you. My name is Finian Worth. 6 years ago, I was the Chief Technology Officer at Vertex Industries, a biomedical data analytics firm positioned to revolutionize how hospitals managed patient outcomes. Before the corner office and the equity discussions, I grew up in a middle-class neighborhood in Ohio, the son of a public school teacher and a civil engineer. My parents taught me that intelligence without empathy is just calculation, that innovation without ethics is just exploitation. Those lessons shaped every line of code I wrote, every contract I negotiated, every hire I made. I came to Vertex as employee number 7, recruited by Prescott Chambers himself during a tech conference in Boston. He had the vision, he said. He had the funding connections. What he needed was someone who could translate his ambitious ideas into functional, scalable technology. The offer was compelling. A generous salary, significant equity, and most importantly, creative control over the technical architecture. What Prescott didn't mention during those early recruitment conversations was his management philosophy. Control through intimidation. Loyalty through fear. Success measured only in acquisition potential, never in actual value delivered to customers. The first year was productive. Our small team operated out of a converted warehouse space in Seattle, fueled by cold brew coffee and the genuine belief that we were building something meaningful. I developed the core algorithm that would become our flagship product, a predictive analytics engine that could identify patient readmission risks with 94% accuracy. Hospitals could intervene earlier, allocate resources more efficiently, save lives. Prescott focused on fundraising. He was exceptional at it. By month 18, we had secured $40 million in Series A funding. The warehouse became a proper office. Employee number 7 became employee 112. My title changed from lead developer to chief technology officer, and with it came a more formal equity agreement. That agreement, drafted by external counsel I had personally vetted, contained language that Prescott's lawyers barely glanced at. Standard intellectual property assignment clauses, they assumed. Boilerplate protection for the company's assets. What they missed was paragraph 17, subsection C, a provisional reversion clause triggered under specific conditions of founder misconduct. I had insisted on it after watching Prescott berate a junior developer to tears over a minor bug. After seeing him take credit for team achievements in board meetings while blaming individuals for any setbacks. The lawyer I worked with, a sharp woman named Hollis Crane who specialized in founder disputes, had raised her eyebrows when I explained what I wanted. "This is unusual," she had said, reviewing the draft language. "You're essentially building a kill switch into the intellectual property rights. If certain conditions are met, core patents and trademarks revert to you personally, not the company." "Is it legal?" I had asked. "Perfectly legal, assuming all parties sign. But Finian, if this ever gets triggered, the company becomes virtually worthless. Everything is built on your core architecture." "That's the point," I had replied. Call it mutually assured destruction. If Prescott ever tries to force me out unethically, he destroys his own company in the process. Hollies had drafted the language with precision. The reversion would trigger if I was terminated without legitimate cause, if my equity was forcibly diluted beyond agreed thresholds, or if I was coerced into resignation through material misrepresentation. The clause required a formal audit request to be filed with the United States Patent and Trademark Office within 72 hours of such triggering event, at which point federal regulators would review the ownership structure and enforce the reversion if conditions were met. Prescott's legal team had signed off on the agreement without truly reading it. They were focused on the equity percentages, the vesting schedules, the standard non-compete provisions. The intellectual property section appeared standard enough that they gave it a cursory review and moved on. 3 years passed. Vertex grew to 300 employees across 4 cities. Our platform was deployed in 87 hospital systems nationwide. Revenue hit $90 million annually. Prescott became a fixture in tech industry publications, profiled as a visionary leader disrupting healthcare. My name appeared occasionally in technical journals, but never in the mainstream press. I didn't mind. The work mattered more than the recognition. But success changed Prescott. The intimidation that had been occasional became constant. The credit stealing that had been opportunistic became systematic. Board meetings became performance theater where he painted himself as the sole architect of every achievement while I and the rest of the executive team were reduced to supporting characters. The breaking point came during an acquisition discussion with a pharmaceutical conglomerate called Axion Global. They were offering $140 million for full ownership of Vertex, with significant earnout potential if performance targets were met. The offer was structured as an asset purchase, meaning they wanted the technology, the customer contracts, and key personnel, but not necessarily the existing equity holders beyond Prescott. In a private meeting I wasn't supposed to know about, Prescott had negotiated a side deal. He would receive $90 million personally. The remaining $50 million would be distributed among investors and employees. My 4.1% equity stake, based on the company's last valuation, should have been worth roughly $5.7 million. Under Prescott's proposed structure, I would receive $800,000 and be required to sign a 5-year employment contract with Axion at my current salary, with no additional equity. I learned about this from Kimberly Oakes, our chief financial officer, who had been excluded from the final negotiations despite being responsible for all financial due diligence. She found me in my office late one Thursday evening, closing the door behind her with obvious agitation. "Finian, I need to show you something," she said, pulling up a document on her tablet. "Prescott's been structuring the Axion deal without executive team input. The terms are problematic." I read through the term sheet she had obtained through a board member contact. The disparity was stunning. Prescott had essentially negotiated to sell the company while retaining most of the proceeds himself, leaving scraps for everyone else who had built the actual value. "This can't be legal," I said, though I knew legality and ethics were different standards. "It probably is legal," Kimberly replied. "As majority shareholder and CEO, he has significant latitude in deal structuring. But it's a betrayal of every conversation we've had about being in this together, about building something meaningful as a team." I thanked Kimberly and spent the next 2 hours reviewing my original equity agreements. The reversion clause was there, unchanged, still active. But triggering it would require Prescott to actually force me out or coerce my resignation. Simply accepting a bad deal wouldn't qualify. The following Monday, I requested a meeting with Prescott to discuss the Axion acquisition. He kept me waiting 40 minutes before his assistant finally escorted me into his office. He didn't look up from his computer when I entered. "What is it, Finian? I'm busy." "I want to discuss the Axion term sheet," I said, remaining standing since he hadn't offered me a seat. "The proposed distribution doesn't align with our equity agreements." Now he looked up, his expression shifting from annoyance to cold calculation. "The proposed distribution is exactly what Axion is willing to pay. If you have a problem with it, you're welcome to walk away. Of course, you'd be walking away from $800,000. Not a decision I'd make lightly if I were you. My equity stake is worth considerably more than $800,000 based on the total acquisition price." Prescott stood, moving to the window with his back to me. Your equity stake is worth what I can negotiate for it. Axion wants me as part of the transition. They want the Vertex brand. They want the customer relationships. Your code, while useful, is ultimately just code. It can be maintained by any competent development team. The dismissiveness was calculated, designed to provoke a reaction. I kept my voice level. I'd like the opportunity to review the full purchase agreement with my own legal counsel before any signatures happen. He turned then, and the mask of corporate civility dropped entirely. You'll review what I tell you to review, you'll sign what I tell you to sign, and you'll be grateful for the opportunity. Do you understand me? I understand that you're attempting to circumvent the equity agreements we all signed in good faith. Prescott's jaw tightened. Get out of my office. The next morning, I arrived to find my office access badge deactivated. My company email was suspended. My direct reports had been instructed to cease all communication with me pending a restructuring review. I was escorted to a conference room where Prescott waited with two people I didn't recognize. A man in an expensive suit carrying a briefcase, and a woman with a laptop who appeared to be some kind of stenographer. Phinean Worth, Prescott began formally. This is Andrew Walsh, outside counsel for Vertex Industries. We're here to discuss the terms of your departure from the company. My departure? I remained standing near the door. I haven't resigned. No, but you will. Prescott slid a document across the table. We've become aware of performance issues that make your continued employment untenable. Missed deadlines, quality problems in code review, complaints from team members about your management style. Rather than pursue a termination for cause, which would be unpleasant for everyone, we're offering you the opportunity to resign voluntarily. Every accusation was fabricated. My performance reviews had been exemplary. My team's retention rate was the highest in the company, but I understood the play. A termination for cause could be litigated, proven false. A voluntary resignation was cleaner, harder to challenge. And if I don't resign voluntarily? I asked. Andrew Walsh, the attorney, spoke for the first time. Then we proceed with termination for cause, which would nullify your equity vesting and potentially expose you to liability for the alleged performance failures. Vertex would be within its rights to seek damages for harm to customer relationships and company reputation. It was a bluff, but an expensive one to call. Litigation could take years and cost hundreds of thousands in legal fees with no guarantee of outcome. Prescott was betting I would take the path of least resistance. I looked at the resignation document. It was comprehensive. Immediate termination of employment, forfeiture of all unvested equity, release of any claims against the company or its officers, and most importantly, a complete waiver of any intellectual property rights beyond what had already been formally transferred to Vertex Industries. Execute this yield, Prescott said, pushing a pen across the table toward me. His smile was predatory. Sign the resignation form. You're done here either way. This version just lets you leave with some dignity intact. The stenographer's fingers hovered over her laptop keyboard, ready to document my response. Andrew Walsh watched with the detached interest of someone who had orchestrated dozens of similar meetings. Prescott leaned back in his chair, utterly confident that the rights were his, that the platform was his, that the $140 million acquisition would proceed exactly as he had planned. I picked up the pen. Smart choice, Prescott said. I signed the resignation document with deliberate care, each letter of my name formed clearly for the record. The stenographer typed. Andrew Walsh witnessed the signature. Prescott's smile widened. What none of them knew was that my signature on that coerced resignation had just triggered the reversion clause buried in paragraph 17, subsection C of my original intellectual property agreement. The clock was now ticking. I stood, leaving the signed document on the table. I'll need a copy of this for my records. Of course, Andrew Walsh said, already preparing a duplicate. Standard practice. I left the Vertex Industries headquarters at 8:47 that morning, carrying a cardboard box with a few personal items from my desk, and a formally witnessed resignation document that Prescott believed had neutralized the last obstacle to his lucrative acquisition. By 9:15, I was in Holly Crane's office across town. She read through the resignation document with increasing concern, then pulled up my original intellectual property agreement on her computer. This is textbook coercion, she said. Fabricated performance issues, threat of termination for cause, forced resignation with equity forfeiture. It triggers the reversion clause definitively. What's the process? I asked. Holly's was already drafting forms. We file an emergency petition with the United States Patent and Trademark Office requesting an immediate audit of the trademark and patent ownership for all Vertex core technology. We include your original IP agreement, the resignation document showing coercion, and declarations establishing that you were the primary inventor of the technology in question. Given the federal regulatory implications and the pending acquisition, they'll likely expedite the review. How quickly can we file? I can have this submitted within the hour. Federal rules require a response within 72 hours for emergency petitions involving acquisition-related disputes. But Finian, you need to understand what this means. If the patent office grants the reversion, Vertex becomes worthless. The entire company is built on your core algorithm and the surrounding patents. Without ownership rights to that technology, they have nothing to sell to Axion. I thought about my team, the 300 employees who would potentially lose their jobs if the acquisition fell through. I thought about the hospital systems relying on our platform for patient care. I thought about the collateral damage of the decision I was about to make. Then I thought about Prescott's sneer as he pushed that pen across the table, about his systematic abuse of everyone who had trusted him, about the culture of fear and intimidation he had cultivated, about the fact that he was about to walk away with $90 million, obtained through deception and betrayal. File it, I said. Holly submitted the emergency petition at 9:53. The Patent and Trademark Office acknowledged receipt at 10:07. At 11:30, Andrew Walsh called my cell phone. Mr. Worth, this is Andrew Walsh, counsel for Vertex Industries. We've been notified of a federal filing concerning intellectual property ownership. I need to understand what you think you're accomplishing here. I'm enforcing the terms of my original employment agreement, I replied calmly. The same agreement your firm reviewed and approved 4 years ago. There was a pause. I could hear papers shuffling in the background. I'm looking at the IP assignment agreement now. I don't see any provisions that would support your claim. Paragraph 17. Subsection C, provisional reversion triggered by coerced resignation or termination without legitimate cause. The silence that followed was longer. When Andrew spoke again, his tone had shifted from dismissive to concerned. I'll need to call you back. At 1:45 that afternoon, my phone rang again. This time it was Prescott, his voice tight with barely controlled rage. What the hell do you think you're doing, Finian? Protecting my rights, the same rights you tried to erase this morning. That clause is unenforceable. My attorneys are reviewing it now, and they assure me no court would uphold such an absurd provision. Then you have nothing to worry about, I said. The Patent Office will review the petition, determine that my claim has no merit, and you can proceed with your acquisition. I'm sure Axion will be happy to wait for federal regulators to sort it out. I could hear him breathing, the sound of someone unaccustomed to losing control of a situation. You're destroying the company. 300 people will lose their jobs because of your ego. I'm enforcing a contract. If the company is destroyed, it's because you built it on a foundation of stolen credit and betrayed agreements. That's not on me. He hung up without responding. The Patent and Trademark Office worked quickly. By Wednesday afternoon, a senior examiner named Theodore Hartley was assigned to the case. His background was in biomedical technology patents, exactly the expertise needed to evaluate my claims. Holly's received notification that a preliminary hearing would be held Friday morning, with both parties required to present evidence supporting their ownership positions. Thursday evening, I received an email from Kimberly Oakes. She had been fired that afternoon, ostensibly for budgetary reasons, but clearly as retaliation for her loyalty to me. The message was brief. He's panicking. Board meeting tomorrow morning before the Patent Office hearing. Axion has paused the acquisition pending resolution. Stand firm. Friday morning arrived cold and clear. The Patent Office hearing room was smaller than I expected, more conference room than courtroom. Theodore Hartley sat at the head of a long table, flanked by 2 technical specialists who would assist in evaluating the patent claims. Holly's and I sat on one side. Prescott, Andrew Walsh, and 2 additional attorneys from a major Seattle firm sat on the other. Theodore opened the proceeding with practiced efficiency. This is an emergency hearing concerning ownership of United States patents 79436881, 8021554, and 8187932, along with associated trademarks for the Vertex Analytics platform. Mr. Worth has petitioned for reversion of these intellectual properties based on alleged breach of employment agreement terms. Mr. Chambers disputes this claim and asserts that Vertex Industries holds rightful ownership. We'll hear from both parties, review the evidence, and issue a preliminary determination. Mr. Worth, your counsel may proceed. Hollies presented our case methodically. The original IP agreement with its reversion clause, documentation of my role as primary inventor on all disputed patents, the coerced resignation with its fabricated performance justifications, emails and Slack messages showing Prescott's pattern of taking credit for my technical work, financial records demonstrating the disparity in the proposed Axion acquisition distribution. Theodore and his technical specialists asked detailed questions about the algorithm development, the patent filing process, and the specific contributions of various team members. I answered each query directly, providing documentation where available. Then it was Prescott's turn. Andrew Walsh presented their counterargument, that the reversion clause was an unconscionable provision that would never be enforced by any reasonable court, that my resignation was voluntary and warranted based on legitimate performance concerns, that Prescott's role as CEO and company founder gave him rightful claim to all work product developed under Vertex's umbrella. Theodore listened without visible reaction, taking notes on a legal pad. When Andrew finished, the examiner looked directly at Prescott. Mr. Chambers, did you personally read and understand paragraph 17, subsection C of the intellectual property agreement before signing it? Prescott hesitated. My legal counsel reviewed all agreements. That wasn't my question. Did you personally read the provision in question? I reviewed the key terms, the equity percentages, the vesting schedules. So you did not read the reversion clause before signing? Andrew Walsh interjected. Your Honor, executives routinely rely on counsel to review complex legal documents. Theodore's expression didn't change. This isn't a court, counselor. I'm not your honor. And the standard here is what the contract actually says, not what the parties wish it had said. The reversion clause is clearly written and was signed by all parties. The question is whether the triggering conditions have been met. He turned to the technical specialists for a whispered consultation that lasted several minutes. Then Theodore looked at both sides of the table. Based on preliminary review, several facts appear undisputed. First, Mr. Worth was the primary inventor on all patents in question, with his name listed first on each filing and his contributions documented in the patent applications themselves. Second, the intellectual property agreement containing the reversion clause was validly executed by all parties, including review by outside counsel for Vertex Industries. Third, Mr. Worth's resignation was solicited under threat of termination for cause based on performance issues that appear to lack documentary support. Andrew Walsh started to speak, but Theodore held up a hand. I'm issuing a preliminary determination that the reversion clause has been triggered, and that ownership of the disputed patents and trademarks provisionally transfers to Finney and Worth, pending final resolution. Vertex Industries is enjoined from representing ownership of these intellectual properties to third parties, including potential acquirers, until a final hearing can be scheduled. Prescott's face went white. You can't do this. We have an acquisition closing in 2 weeks. This decision will kill the deal. Theodore closed his folder with finality. Then you should have read your contracts more carefully, Mr. Chambers. Final hearing is scheduled for 60 days from today. This proceeding is adjourned. The silence in the hearing room was absolute. Andrew Walsh and his colleagues immediately huddled around Prescott, voices low and urgent. Hollies gathered our materials calmly, professionally, but I could see the slight smile at the corner of her mouth. As we exited into the hallway, my phone buzzed with an email from Axion Global's general counsel. The message was terse. Acquisition discussions suspended pending resolution of IP ownership dispute. We will not proceed without clear title to core technology assets. By Monday morning, the story had leaked to the trade press. Vertex Industries acquisition in jeopardy over IP dispute. Read the headline in a biomedical technology newsletter. The article detailed the patent office hearing and the preliminary determination, though it lacked the full context of Prescott's coercion and the reversion clause mechanics. Kimberly texted me a screenshot from the company's internal Slack. Prescott had posted a message attempting to reassure employees that the situation was under control, that legal challenges were routine in acquisition processes, that everyone should continue focusing on their work. The comments below his message told a different story. Confusion, anger, demands for transparency. The following weeks were a masterclass in corporate collapse. Axion formally withdrew from acquisition discussions, citing unresolved material issues with asset ownership. Vertex's investors, who had been counting on the acquisition as their exit opportunity, turned on Prescott in a series of contentious board meetings. 3 members of the executive team resigned, unwilling to be associated with the unfolding debacle. Prescott tried multiple angles to resolve the situation. He offered me a settlement, full equity value based on the original Axion offer if I would withdraw the patent office petition and sign a clean IP assignment. I declined through Hollies, who pointed out that the offer proved he had been attempting to shortchange me in the first place. He tried to negotiate directly with the patent office, arguing that the public interest would be harmed if the Vertex platform became unavailable to hospitals due to an ownership dispute. Theodore Hartley responded in writing that ownership disputes were precisely what the patent system was designed to resolve, and that Vertex remained free to license the technology from the rightful owner once that owner was definitively established. He even attempted to have his legal team argue that I had somehow fraudulently inserted the reversion clause into the agreement without proper disclosure. That argument collapsed when Hollies produced email chains showing that Prescott's original counsel had specifically reviewed and approved that section, with notations in the margin indicating they understood its purpose, even if they hadn't grasped its full implications. The final hearing occurred on a gray afternoon in early November, nearly 8 weeks after the initial confrontation in Prescott's office. The hearing room was the same, but the atmosphere was different. Prescott looked diminished, the arrogance replaced by desperation. Andrew Walsh had been replaced by a new lead attorney, a woman named Simone Lattimore who specialized in patent litigation and had apparently advised Prescott that his position was functionally indefensible. Theodore Hartley opened the final hearing with the same efficiency he had demonstrated initially. "We're here to make a final determination on the ownership of the intellectual properties in dispute. Both parties have submitted additional briefs and evidence. I've reviewed all materials, consulted with technical specialists, and obtained advisory opinions from the Patent Office's Ethics Division regarding the enforceability of conditional reversion clauses. Is there anything either party wishes to add before I issue the final ruling?" Simone Lattimore stood. "Your Honor, Vertex Industries would like to propose a resolution. We acknowledge that the preliminary determination was based on substantial evidence and that our likelihood of prevailing on the merits is limited. We propose that ownership of the disputed patents revert to Mr. Worth as specified in the original agreement, but that Vertex retains a perpetual, royalty-bearing license to continue using the technology in its current platform." I glanced at Hollies, who gave a subtle nod. We had discussed this possibility. A license would allow Vertex to continue operating, preserving jobs and customer relationships, while recognizing my ownership rights and providing ongoing compensation. "What royalty structure are you proposing?" Theodore asked. Simone referred to her notes. 15% of gross revenue derived from the platform technology, paid quarterly, with audit rights to verify accurate reporting. It was a reasonable offer, roughly industry standard for essential patent licenses. But I wasn't interested in reasonable. I was interested in justice. "Counterproposal," Holly said, standing. "Full ownership reverts to Mr. Worth as specified in the agreement. Vertex Industries receives a 5-year license at 25% of gross revenue, after which the license must be renegotiated or terminated. Additionally, Prescott Chambers must resign as CEO and divest all equity holdings within 90 days. The demand hit like a thunderclap. Simone looked stunned. Prescott half rose from his chair, his face flushing. "You can't force me out of my own company." Theodore's voice cut through the disruption. "Mr. Chambers, sit down. This is a negotiation, not a final ruling. Both parties are entitled to propose terms." Prescott remained standing. This isn't about the patents. This is about revenge. He's trying to destroy everything I built because his ego can't handle not being the center of attention. I spoke for the first time in the hearing. I'm trying to ensure that the company survives under leadership that doesn't view employees as disposable assets and contracts as suggestions. You built Vertex on other people's work while taking sole credit. You negotiated a sweetheart acquisition deal that betrayed everyone who trusted you. You fabricated performance issues to force me out when I questioned your ethics. This isn't revenge, Prescott. This is consequences. Theodore let the silence settle before speaking. Here's what's going to happen. I'm issuing a final ruling that ownership of all disputed patents and trademarks reverts to Finian Worth, effective immediately. The reversion clause was clearly written, properly executed, and legitimately triggered by Mr. Chambers' coercive termination tactics. As for licensing terms, that's a private matter between the parties. You have 30 days to negotiate a license agreement or Vertex Industries will need to cease using the technology entirely. This hearing is concluded. The gavel fell with a finality that seemed to echo in the small room. Negotiations over the license terms took the full 30 days. Prescott was removed as CEO by the board of directors, who recognized that his continued leadership made any settlement impossible. They installed an interim CEO, a former hospital system executive named Roland Kemp, who approached the situation with pragmatism rather than ego. Roland and I met at a neutral location, a coffee shop equidistant from both our homes, without lawyers present. He was in his early 60s, with the calm demeanor of someone who had navigated enough corporate crises to recognize when fighting was counterproductive. I'm not here to relitigate who was right or wrong, he began. Prescott made serious errors in judgment, and the board has addressed that. I'm here to find a path forward that preserves what 300 people built together. I appreciated the directness. I don't want Vertex to fail. I want it to succeed under leadership that values people appropriately. Then let's find terms we can both live with. We negotiated for 6 hours, taking breaks to consult with our respective attorneys, but always returning to the conversation ourselves. The final agreement reflected a balance. Vertex would pay 20% of gross revenue for a 7-year license term, with an option to extend for another 7 years at renegotiated rates. I retained all ownership rights and the ability to license the technology to other parties in non-competing markets. Prescott would divest his holdings over 12 months, with proceeds distributed proportionally to all equity holders based on their original agreements. Most importantly, the agreement included governance reforms. The board would be expanded to include employee representatives. Executive compensation would be tied to employee satisfaction metrics, not just financial performance. Any acquisition discussions would require full transparency with the executive team and equitable distribution based on original equity agreements. Roland signed on behalf of Vertex Industries on a Wednesday afternoon in December. I signed immediately after. Hollies and Simone Lattimore witnessed both signatures. You could have destroyed the company, Roland said as we prepared to leave. A lot of people in your position would have. Destruction was never the goal, I replied. Accountability was. The ripple effects of the case extended far beyond Vertex Industries. Technology industry publications ran detailed analyses of the reversion clause mechanism, prompting hundreds of founders and early employees to review their own IP agreements with fresh scrutiny. Several law firms began offering worth clause provisions as standard options in employment contracts for key technical personnel. Prescott Chambers divested his Vertex holdings as required, walking away with roughly $12 million after taxes and legal fees. A significant amount of money, but far from the $90 million he had attempted to secure through the Axion deal. He attempted to launch a new venture 6 months later, but investors were wary. The Vertex debacle had permanently tarnished his reputation. His new company folded within 18 months due to inability to secure adequate funding. Kimberly Oakes was rehired by Vertex under Roland's leadership, promoted to Chief Operating Officer with expanded responsibilities. She implemented new HR policies designed to prevent the kind of toxic culture that had flourished under Prescott. Employee retention improved dramatically. Several people who had left during the chaos returned. The platform continued to grow under the licensing agreement. Vertex expanded to 130 hospital systems and 12 international markets. My 20% royalty stream became substantial, far exceeding what my original equity would have been worth under even the most generous acquisition scenario. But the money, while meaningful, wasn't the point. The point was demonstrated in an email I received 2 years after the final hearing. It came from a developer named Wesley Harper, someone I had hired during my time as CTO but hadn't kept in close contact with. Finian, I wanted you to know that what you did mattered beyond just your situation. Last month, my current employer tried to push me into signing away patent rights for an invention I developed largely on my own time. I remembered the Vertex case and consulted an attorney who helped me negotiate fair terms instead. Your willingness to fight back showed people like me that we don't have to accept exploitation as the cost of working in this industry. Thank you. That email was worth more than any royalty payment. I eventually started my own consulting firm, helping early-stage companies structure equitable IP agreements and build cultures of genuine collaboration rather than exploitation disguised as teamwork. The firm remained small by design, never more than 15 people, but the impact rippled outward through the dozens of companies we advised. One of those companies was founded by former Vertex employees who had left to pursue their own vision. They asked me to serve as a technical advisor and offered equity terms that included a worth clause, named explicitly for the provision that had reshaped their understanding of fair dealing. I accepted, touched by the recognition that the fight had been about principles larger than any individual situation. 5 years after the confrontation in Prescott's office, I received an unexpected LinkedIn message. It was from Andrew Walsh, the attorney who had presided over that initial coercive resignation meeting. The message was brief. I wanted to apologize for my role in the Vertex matter. At the time, I viewed it as standard employment negotiation. In retrospect, I understand I was facilitating a significant ethical breach. I've since revised my practice to decline representations where the goal is coercing resignations through fabricated performance issues. Your case changed how I think about my professional obligations. I appreciated the message more than I expected to. Accountability and growth were possible, even for those who had been on the wrong side initially. The story of Vertex Industries and the reversion clause became something of a legend in Seattle's technology community, often told in simplified form that missed the complexity and pain of the actual experience. Some versions portrayed me as a vengeful employee who had sabotaged a successful company. Others painted me as a hero fighting corporate malfeasance. The truth, as usual, was more nuanced. I had made strategic decisions to protect my interests, yes. But those decisions were grounded in principles my parents had instilled decades earlier in Ohio. That agreements mean something, that people deserve fair treatment, that intelligence without integrity is just calculation. The platform I built continues to save lives. That was always the goal, from the first lines of code written in that converted warehouse space. Hospitals use the predictive analytics to intervene before patients deteriorate, to allocate scarce resources efficiently, to identify systemic care gaps that would otherwise remain invisible. The technology works because it was built by people who cared about the mission, not just the exit opportunity. Roland Kemp retired from Vertex 3 years into his tenure, replaced by a permanent CEO who had come up through the healthcare industry rather than the venture capital world. The company remains independent, profitable, and by all accounts a substantially better place to work than it was under Prescott's leadership. I still hear from former colleagues occasionally. Updates on their careers, invitations to speak at conferences, requests for advice on navigating their own complex professional situations. Each conversation reinforces that the confrontation with Prescott, as difficult as it was, sent a message that extended far beyond one company or one contract dispute. That message, power imbalances in professional relationships are real, but they're not insurmountable. Contracts matter. Documentation matters. Having the courage to enforce your rights matters even when the personal cost is high. The reversion clause, that paragraph 17 subsection C that Prescott's attorneys had dismissed as boilerplate, was my insurance policy against exactly the kind of exploitation he eventually attempted. It worked because I had the foresight to negotiate it when I had leverage, and the resolve to enforce it when that leverage was tested. To those building careers in industries where intellectual capital is the primary asset, the lesson is straightforward. Understand what you're signing, document your contributions, and never assume that today's collaborative relationship will remain intact when significant money enters the equation. Protect yourself not because you expect betrayal, but because preparation is the only defense when betrayal arrives unexpectedly. The corporate vault channel exists to share these experiences because knowledge is protection. Real situations from business environments reveal patterns that theory alone never captures. If this story resonated with your own professional experiences or concerns, consider subscribing as we build toward that community of 1,000 people who understand that workplace integrity isn't idealism. It's survival strategy. The corporate world rewards preparation, documentation, and the willingness to enforce boundaries when they're crossed. That morning in the conference room when Prescott sneered, "Execute this yield," and pushed that resignation document across the table, he was certain he held all the power. He controlled the company, the board, the acquisition negotiation, the narrative. What he didn't control was the contract language he had signed without reading, the federal regulatory process that enforces intellectual property rights, and most critically, the resolve of someone who understood that some fights are worth having regardless of the cost. His smile turned to panic not in that moment, but at 9:15 when the trademark audit notification hit, and he realized the billion-dollar launch was built on a foundation that was never his to control. The $140 million platform seized by federal regulators, because ownership had reverted to the person who actually created it. Sometimes justice requires years of litigation and uncertain outcomes. Sometimes it requires only that someone read the contract carefully enough to understand what protections already exist and have the courage to enforce them when necessary. The name on those patents is mine now. The royalty payments arrive quarterly. The platform continues to evolve and expand. And somewhere Prescott Chambers is learning that shortcuts always have costs, even if those costs arrive years after the initial decision. That's the real yield. Not the document he demanded I execute, but the consequences he generated through his own choices. And those consequences will keep compounding for as long as the technology I built continues to create value in the world.